Good morning.
Morning.
Good morning. The time is now 10 a.m. and I will call the meeting of the District of Columbia Board of Ethics and Government Accountability to order. I'm Bega Chairperson Norma Hutcheson, and this meeting is being held at the Board of Ethics and Government Accountability at 1030 15th Street Northwest in Suite 700 West and virtually. Joining me for this meeting are board members Charles Nottingham, Felice Smith, and Melissa Tucker. Together, the four of us constitute a quorum for this meeting. Since it was first posted, there have been no changes to the agenda, so we will need a motion to approve the agenda.
Make that motion to approve the agenda.
Okay, is there a second?
I'll second it.
Okay, it's been moved and seconded that we adopt the agenda for today's meeting. Anyone, all in favor, please say aye.
Aye.
Any nays? Hearing none, the board has adopted the agenda for today's meeting. Before us today are the meeting from the March 2026 draft meeting minutes. Please review those and we'll need a motion to approve the meeting minutes.
I'll offer the motion that we approve the minutes from the previous meeting.
Okay, is there a second?
I was absent from that meeting, so I'm going to
Okay.
second.
Okay, it's been moved and seconded that we approve the meeting minutes from March 2026. All in favor indicate by saying aye.
Aye.
Aye. Any opposed? Hearing none, the board approves the March 2026 meeting minutes. Next on the agenda is a report from the Office of Open Government. Director Allen, please proceed.
Thank you and good morning, Chairperson Hutcheson and members of the board. I am Niquelle Allen, Director of Open Government, and I am pleased to present this report on the activities of the Office of Open Government, or OOG. Our mission is to ensure that all persons receive full and complete information concerning the affairs of the District of Columbia government and the actions of its officials. Since the last board meeting, OOG has continued its work to ensure that the District of Columbia's government's operations are transparent, open to the public, and promote civic engagement. To that end, OOG has enforced the Open Meetings Act, advised on the Freedom of Information Act requirements, and provided training on those transparency laws. OOG has proudly served as advocates for an open and transparent government. First is Open Meetings Act and Freedom of Information Act advice. Advisory opinions. OMA advisory opinion, Board of Trustees for Creative Minds International Public Charter School, number OOG-2025-0014. On March 30th, 2026, I issued this opinion in response to a complaint which alleged that Creative Minds International Public Charter School Board failed to publish the location and times of its meetings. I found that the Creative Minds Public Charter School Board did not violate the Open Meetings Act. OOG's investigation revealed that the board's complete meeting notices for upcoming meetings were posted on the public charter school's website. The board stated the location of its in-person meeting on the board's designated webpage of the public charter school's website and in the meeting notices linked to the webpage. As such, the board was found in compliance with the Open Meetings Act. I dismissed this matter pursuant to 3 DCMR Section 10403.1B and 3 DCMR Section 101403.1F, respectively, because the allegation of unpublished times of the board meetings was not substantiated and the board did not violate the Open Meetings Act. I also advised the board to post its annual schedule with no other events on the Creative Mind Public Charter Schools webpage designated for the board's information. Creative Mind Public Schools general calendar has the dates and times of the board's meetings, which is helpful but does not constitute an annual schedule of the board's meetings as required by the Open Meetings Act. A copy of the complaint and advisory opinion have been added to Dropbox. The second advisory opinion is OMA Advisory Opinion Community Review Panel number OOG-2025-0055. On April 1st, I issued this opinion. On August 1st, 2025, I received a request to advise the Office of the State Superintendent of Education on whether its Community Review Panel, CRP, or the panel is subject to the Open Meetings Act. I issued the opinion sua sponte since the request did not come from the public body and was not an Open Meetings Act complaint. My advice concluded that based on the statute establishing the panel and how the Open Meetings Act covered a public body, the panel is a time-limited advisory review mechanism to OSSI, not an independent deliberative public body, and is therefore not subject to the Open Meetings Act. DC Official Code Section 38-2572.02 establishes the statutory framework for special education due process hearing independence. The operative provisions require OSSI to 1, submit potential hearing officer candidates to a 7-member community review panel for evaluation, 2, ensure the panel is composed of specific stakeholder categories, attorneys, educators, DCPS representatives, and local education association representatives, and parents. 3, prohibit members from being OSSI employees, and 4, have the panel move forward recommendations to the State Superintendent of Education after reviewing candidates. The statute does not require the Office of the State Superintendent to grant the panel delegated decision-making authority. The panel does not function as an advisory body to OSSI, and it does not take official action by the vote of its members convened to recommend candidates for hearing officer positions. For the reasons stated in the opinion, OSSI was advised that the Community Review Panel is not subject to the OMA. A copy of the request for the OMA advice and the advisory opinion are in Dropbox. Informal advice. Since the last board meeting, the Office of Open Government has responded informally via email, telephone, or teleconference to requests for assistance as follows: 10 requests for Open Meetings Act advice, 11 requests for Freedom of Information Act advice, and 14 requests for technical assistance with open-dc.gov. Meeting monitoring. OOG staff attends public body meetings in person and remotely to ensure compliance with the Open Meetings Act. They also inspect public bodies' websites and the OOG Central Meeting Calendar for public meeting notices and records. OOG's attorneys provide legal advice on the Open Meetings Act compliance and take corrective action if necessary. Since the last board meeting, OOG's legal staff have attended 15 public body meetings. As a result of the monitoring, 4 corrective measures were communicated. The public body failed to 1, publish a meeting notice on its website, 2, publish an annual schedule of its meetings, 3, publish a complete meeting notice on the central meeting calendar, which includes the OMA citation on the agenda for entering closed or executive session, and 4, publish certain of its meeting minutes. Training and outreach is next. Mandatory responsible AI training for DC government employees and contractors. OOG staff has completed the following mandatory responsible AI training for DC government employees and contractors, quote, using generative AI in government, and quote, understanding risk and building resilience. The District of Columbia has partnered with the company Innovate US to provide online training which supports Washington, D.C.'s citywide approach to responsible artificial intelligence established under Mayor's Order 2024-028. The order requires agencies to demonstrate public benefit, protect privacy and equity, and preserve human accountability before deploying AI tools. 2, District of Columbia Bar Paralegal and Legal Assistant Training Program 2026, Parts 1, 2, and 3. On March 9th, 16th, and 30th, 2026, paralegal specialist Kimberly Brown attended the 3-part series of the DC Bar Paralegal and Legal Assistant Training Program held at the DC Bar Conference Center. This expert-led training was designed to strengthen the effectiveness of paralegals and legal assistants students across practice settings by delivering practical instruction. The program included a variety of learning sessions on legal writing, research, discovery, ethics, guidance on effective attorney collaboration, and an introduction to the responsible use of legal technology, including artificial intelligence. A list of courses is in Dropbox. Open Meetings Act training for DC Public School Local School Advisory Team, or LSATs. On March 11th, Attorney Advisor Joan Lelma facilitated an OMA training for DC Public School Local Advisory Teams. The training was the first in OOG's 2026 training series for the LSATs. I attended this training virtually. DC FOIA Basic Training for New FOIA Officers. On March 19th, Trial Attorney Brandon Lewis facilitated a FOIA training for new FOIA officers. This session provided basic overview of the DC Freedom of Information Act. I, along with Chief Counsel Neal, Attorney Advisor Skirbo, and Paralegal Specialist Brown, attended the training. Digital Government Institute, DGI, 23rd Annual E-Discovery Records and Information Management Conference. On March 19th, Attorney Lelma attended this conference hosted at the Ronald Reagan Building. 10 sessions presented at this immersive event explored practical strategies for preserving, collecting, and reviewing digital information with a focus on transparency, data reliability, and operational resilience. Among the presenters were the Honorable Tanya R. Kennedy, Associate Justice, Appellate Division, First Judicial Department, Supreme Court of the State of New York. Justice Kennedy provided an appellate perspective on generative AI with a focus on ethical duties and disciplinary consequences, and discussed the future of digital evidence. Litigation and legislative update is next. Litigation. First case is Council of the District of Columbia versus Muriel Bowser, case number 2026-CAB-001463 in DC Superior Court. On March 5th, the Council of the District of Columbia, the council, filed a complaint for declaratory and injunctive relief against Mayor Muriel Bowser in her official capacity as Mayor of the District of Columbia. The complaint alleges that the mayor unlawfully refused to provide the council with certain agency budget enhancement requests for FY 2025 and FY 2026 that had been requested by council committees as part of the council's ongoing performance oversight process. The complaint further alleges that the council anticipates the mayor's refusal to provide any agency budget enhancement requests for FY 2027. The mayor filed in opposition to the council's motion on March 16th, and the council filed a response on March 17th. A motion hearing was held on March 17th, at which the court denied the council's request for a temporary restraining order, or TRO. I, along with OOG staff, attended the hearing virtually. The motion for preliminary injunction remains pending. The court issued an order on March 20th denying the motion for TRO and setting aside an expedited summary of the judgment briefing schedule. The council was ordered to file its motion for summary judgment on or before March 31st. The mayor's combined opposition and cross motion for summary judgment are to be filed on or before April 17th. The council's combined reply and cross opposition are due on April 24th, and the mayor's reply must be filed on or before May 1st. Copies of the documents have been added to Dropbox, and OOG staff will continue to monitor this case. Terrace, Plavick, and Millen, LLP versus the District of Columbia, case number 2020-CA-003087B in DC Superior Court. This is an update on the case filed by TPM against the district under DC FOIA, alleging that the district failed to produce and post online various budget-related documents related to the Office of the State Superintendent of Education and the District of Columbia Public Schools. At the last board meeting, I provided details on the plaintiff's motion for contempt and further injunctive release. The court ruled on this motion on February 11th and issued an order granting it in part. On February 26th, the court heard arguments on the motion for contempt. The court set a deadline of March 4th for the district to produce the records. A status hearing was held on March 17th. I, along with OOG staff, also attended this status hearing virtually. The plaintiff represented that it was satisfied with the district production in the response to the court's February 11th contempt order. The court ordered contempt sanctions issued against the district vacated, finding that the district had purged its contempt. The court held that the plaintiff's request for further injunctive relief remain held in abeyance until further order. A status hearing has been set for June 5th. A copy of the court's order has been added to Dropbox, and OOG staff will continue to monitor this case as well. Legislation is next. Legislative action concerning the Open Meetings Act. DC Law 2624, the Open Meetings Temporary Amendment Act of 2026, expired on March 29th, 2026. The following council measures will prevent a gap between the expired temporary measure and the committee of the whole markup of the permanent bill. On March 30th, Chairman Mendelson introduced PR 26-0584, the Open Meetings Clarification Emergency Declaration Resolution of 2026, Bill 26-0632, the Open Meetings Clarification Emergency Amendment Act of 2026, and Bill 26-0633, the Open Meetings Clarification Temporary Amendment Act of 2026. The Open Meetings Clarification Emergency Declaration says as follows: it is to declare the existence of an emergency with respect to the need to amend the Open Meetings Act of 2010 to clarify the definition of a meeting, to provide for a public body's ability to be briefed about potential terrorist or public health threats, so long as no official action is taken, to exempt from the act meetings between the council and the mayor, provided that no official action is taken at such meetings, and to provide that a meeting shall be deemed open to the public if the public body takes steps reasonably calculated to allow the public to view or hear the meeting while the meeting is taking place, or if doing so is not technologically feasible, as soon thereafter as reasonably practicable. On March 31st, this resolution passed by a vote of 11-2 and became effective immediately. Bill 260632, the Open Meetings Clarification Emergency Amendment Act of 26, and Bill 26-0333, the Open Meetings Act Clarification Temporary Amendment Act of 2026, is as follows. On March 31st, this passed by a vote of 9-3, Bill 26-0632, with one member voting as present. It became effective as of March 29th, 2026, and is effective for no more than 30 days. Bill 26-0633 passed the council by a vote of 8 members voting yes, 3 members voting no, and 2 members voting present. The second reading is tentatively scheduled to be voted on May 5th before the recess. If passed, the bill will become retroactively effective as of March 29th, 2026, and will be effective for no more than 25 days. Copy of a resolution and bills are in Dropbox. In addition to the Open Meetings Act, Section 2 of the District of Columbia Boards and Commissions Financial Reporting Temporary Amendment Act of 2025 was added to the Open Meetings Act bill by striking the phrase April 3rd, 2026, and inserting the phrase October 17th, 2026 in its place. Chairman Mendelson indicated that he will likely move a permanent measure regarding the Open Meetings Act and financial reporting, possibly before the recess. Legislative action regarding body-worn camera regulation and reporting requirements of 2015. This is FOIA related. I reported on these council measures at the last board meeting. They expand the body-worn camera law to require faster automatic public release of key footage in serious incidences, going beyond the slower and more limited disclosure normally available through FOIA. The resolution makes transparency the default, not something only available after a FOIA request. The bills temporarily expand the law, so body-worn camera footage must be released whenever an MPD officer is present during a serious use of force incident, even if the force was used by another agency like a federal officer. They also require the release of all names of law enforcement officers involved. Mayor Bowser sent a letter to the council before the legislative meeting opposing the legislation and expressing her view that these matters matters are appropriately handled by Congress. On March 6th, the council voted unanimously to pass the resolution PR 260562, which declared the sense of the council relative to an emergency regarding the need to require the Metropolitan Police Department officers to document identifying information for all law enforcement officers present at an arrest and any use of force supporting the arrest, as well as the companion bill 26-0614, which required on an emergency basis MPD officers to document identifying information as above. However, the mayor vetoed the bill 26-0614 on March 23rd. On March 31st, Councilmember Robert White made a motion and the council voted unanimously to override the veto. The council then voted unanimously to approve the measure. Copy of the resolution and bill are in Dropbox. Full Accountability and Arrest Reporting Temporary Amendment Act of 2026, Bill 26-0615. On March 3rd, the bill passed unanimously after first reading. PR 26-0563, the Body-Worn Camera Transparency for the Use of Force Emergency Declaration Resolution Act of 2026, and Bill 26-0616, the Body-Worn Camera for the Use of Force Emergency Amendment Act 2026, and the Body-Worn Camera Transparency for Use of Force Amendment Act of 2026 are as follows. Of the measures introduced by Councilmember Pinto regarding body-worn cameras, the emergency resolution declaring the existence of an emergency with respect to the need to amend legislation and regulations to require the release of body-worn camera recordings of MPD officers present at the event of an officer-involved death or serious use of force by law enforcement officer other than a Metropolitan Police Department officer, and applies retroactively to August 1st, passed unanimously with amendment and became effective immediately. It was published in the DC Register on March 13th, 2026. On March 23rd, the mayor signed the emergency bill 26-0616 as Act A 26-0282, which will be in effect until June 21st. Due to it being emergency legislation, by law it is only in effect for 90 days. March 3rd, 2026, Bill 26-0617 passed unanimously on its first reading. The next step is second reading. Copies of the signed law as well as the passed bills and resolutions are available in Dropbox. Reports to the council, as the mayor of the District of Columbia and the Attorney General for the District of Columbia are required to provide annual FOIA reports to the council. The Metropolitan Police Department is required to submit body-worn camera report to the council every 6 months. The Executive Office of the Mayor and the District of Columbia transmitted the district's annual FOIA report arising under FOIA to the council on March 4th. The Attorney General for the District of Columbia released its FY 2025 annual litigation report on January 29th. Copies of these reports are in Dropbox. Last in my report are administrative matters. The FY 26 budget proposal. On March 18th, the council issued a notice of public hearing for the FY 2027 budget. The council committee's fiscal oversight hearings on the FY 2027 budget proposal were announced for April 6th to April 30th, 2026. The Committee on the Judiciary and Public Safety did not provide a hearing date for the Board of Ethics and Accountability. The mayor was due to submit the Local Budget Act and the Budget Support Act for the FY 2027 budget on April 1st, but the Chief Financial Officer continues to work on the FY 2027 budget submission. This concludes the Office of Open Government's April 2nd, 2026 report. I'm happy to answer any questions that the board may have.
Thank you, Director Allen. Are there any questions for Director Allen? Okay, seeing none. I just know for the record that Board Member Darrin Sobin is with us.
Apologies for my tardiness, folks. The concierge was not at the desk.
That's okay. All right. Next on the agenda is a report from the Office of Government Ethics. Director Ashley Cooks, please proceed.
Good morning, Chairperson Hutcheson and members of the board. I'm Ashley Cooks, the Director of the Office of Government Ethics. I'm pleased to present this report on the activities of the Office of Government Ethics, OGE. First is an update on the status of OGE investigations. The information reported today regarding OGE's cases will not reflect any status changes that may occur because of actions taken by the board during today's meeting. For open investigations by status, we have 64 matters. Open undocketed matters, we have 1. Pending state investigations by status, we have 33 matters that are closed pending collection, 3 matters stayed pending DC Superior Court case, 3 matters stayed for OIG investigation, 2 matters stayed for U.S. District Court case for a grand total of 41. For regulatory matters by status, we have 67 matters that are closed pending collection, 633 matters that are open for a grand total of 700. Again, we currently have 64 matters that are open and 8 matters that are stayed. The number of open preliminary and formal investigations includes 12 new matters. The investigative team resolved 31 investigations since the board last met. This total does not reflect the number of complaints that were dismissed for a lack of jurisdiction. For an update on training and outreach, first is an update on professional development trainings attended by staff. Since the last board meeting, Administrative Officer Niquelle Allen completed 2 PeopleSoft courses entitled Contract Administrator and FMLA Coordinator Training, and a course entitled Finance and Budgeting Essentials. Auditor Courtney Walker completed PeopleSoft courses Effective Interpersonal Communication and Conscious Leadership. Chief of Staff Christina Mitchell took 2 PeopleSoft courses entitled Giving and Receiving Feedback and HR Law, and 2 other courses entitled Understanding Burnout and Causes and Responsible AI for Public Professionals Using Regenerative AI in Government. HR Specialist Megan Stoudemire took a course entitled Disability Awareness Training, Exit Basket. Lastly, myself, Senior Counsel Tran, General Counsel Aja Stewart Mitchell, and Supervisory Attorney Advisor Amber Anderson attended a Kogel Connect session entitled Public Corruption Post-McDonald, Considerations for the Present and the Future. For trainings conducted by staff, since the last board meeting, OGE conducted 7 training sessions, the March monthly ethics training, the March monthly Hatch Act training, 2 new employee orientation ethics segments, an ethics training for the Department of General Services, a monthly virtual brown bag session for ethics counselors, and the quarterly lobbyist registration and reporting training. In March, 1,231 people took ethics training via PeopleSoft, and 61 users accessed the LMS and completed courses. 120 new employees attended new employee orientation and received information on the district's ethics rules in March. Next is an update on advisory opinions and advice. First is informal advice. OGE's legal staff provided advice for approximately 34 ethics inquiries, which is 8 more than the 26 reported at the March meeting. This number does not include responses we are provided to questions regarding the lobbyists and FDSE filing systems. For formal advisory opinions, OGE has not issued any formal advisory opinions since the last board meeting. Next is an update on legislation and rulemaking. First is the only update there is council legislation affecting financial disclosure. That is B26-0325, Board of Ethics and Government Accountability Authority Clarification Amendment Act of 2025 is still pending. This legislation is in response to Bega's rulemaking, which designated 43 board and commissions as public financial disclosure statement filers and would repeal Bega's authority to make such designations in the future. Chairperson Hutcheson and I testified at the public hearing regarding this legislation on January 13, 2026. Council Chairman Mendelson has indicated that he will amend this legislation with the intent to have it passed before the council's recess. This past Tuesday, the council passed B26-0633 and B26-0632, which are emergency and temporary legislation that halt the applicability of Bega's rulemaking until October 17, 2026. This is the third time that the council has passed this type of emergency and temporary legislation, thereby relieving certain public officials of their obligation to file financial disclosure statements since the rulemaking was finalized. None of the boards and commissions have filed a statement with Bega. Given that financial disclosure is a key to promoting public trust and transparency within the district government, any legislation that hinders that process does not serve the interests of the government or the residents of the city. Nonetheless, Bega will continue its efforts to promote an ethical and transparent government by educating and advising employees on the ethics rules and holding accountable those public officials who violate the ethics rules. Next is an update on OGE administrative matters. Staffing. OGE welcomes our new supervisory attorney advisor, Amber Anderson. Supervisory attorney Amber Anderson went to Tulane University School of Law, and she joins us from the Federal Aviation Administration, where she worked as an attorney advisor in the Office of Chief Counsel for Ethics and Compliance. Amber has worked as a designated agency ethics official and has 10 years of government ethics experience. OGE also welcomes investigator Ayanna Talley. Investigator Talley obtained a master's in criminal science investigation from Stevenson University. She joins us from the Department of Youth Rehabilitation Services, where she was an investigator. Next is an update on financial disclosure statement, FDS. Pursuant to DC Official Code Sections 1-1162.24 and 1-1162.25, public officials and certain government employees who must file a financial disclosure statement as a means of transparency to prevent engaging in conduct that creates a financial conflict of interest must file their statement with Bega. Bega is responsible for ensuring that employees and public officials who meet the statutory obligation file their annual financial disclosure statement. We are excited to kick off FDS season 2026. The FDS team sent out the 2026 agency head memo, which is OGE's initial request for information and instructions that launches the season. The agency's filers list were due to OGE on March 2nd, 2026, and OGE has received all the lists. This year, 9,236 filers are required to file by statute or were designated to file by their agency. We are coordinating the paper mailing notice of the initial public disclosure statement notification, and will send notification to this year's filers on April 15th, 2026. Last is an update on lobbyist registration and reporting. Pursuant to DC Official Code Section 1-1162.27A, a person who receives compensation or expends funds in an amount of $250 or more in any 3 consecutive calendar month period for lobbying shall register with the Director of Government Ethics and pay the required registration fee. According to DC Official Code Section 1-1162.30, each registrant shall file a quarterly report concerning the registrant's lobbying activity during the previous quarter. On March 13, 2026, fine notices were sent to lobbyists who failed to timely file. Attorney Advisor Eccles and Program Coordinator Kosick hosted the quarterly lobbyist training on March 18th, and 24 lobbyists attended. A notice announcing the 2026 Q1 activity reports announcing that they're due on April 15th was sent out to all current registrants and clients. Thank you. This concludes the Office of Government Ethics, April 2nd, 2026 report. I welcome any questions you may have.
Thank you, Director Cooks. Are there any questions for Director Cooks?
Well,
Okay.
just a welcome to the new attorney, a new investigator. Welcome aboard.
Welcome.
And I was just going to ask you about the lobbyist registration and reporting, because we have some fines to deal with today. And again, it seems to be people claiming that they're not familiar with their obligations. Do you think there's any utility in maybe in the future requiring training as a condition of being a lobbyist in the district? And, you know, this is kind of the same way we do at the DC bar, where you have to take an ethics course within 12 months of becoming an attorney, an all-day ethics course. It's the only mandatory continuing legal education we have in the district. And if you don't take it, after 12 months, you get suspended from being an attorney. It's not a disciplinary suspension, it's an administrative suspension, but still you can't practice law. And so I'm just wondering if lobbyists, it might cut down on the fines that we're handing out these days, and they may be happy to avoid fines of thousands of dollars if it means just complying with a mandatory training course. So I'll leave that to you guys to mull over.
I do believe that a mandatory training requirement is necessary for lobbyists, and we have proposed such legislation to the council a couple of times, but it has not passed. It is common in other jurisdictions that lobbyists do have to take a annual training, so I think it will make a difference in the District of Columbia. I plan to talk with Councilmember Pinto about adding that to our statute, as well as removing the exemption for 501c4 entities.
Well, instead of an annual training, which could be burdensome, I would say a one-time training when you register to become a lobbyist, maybe, because really what we want them to do is understand the obligations they have as a lobbyist and what it actually means to lobby. And if we have those two things, you know, I don't see how doing it every year, and you might get pushback on something like that.
Once a year, at least something that mandates they attend training. So once a year, once when registering
Right.
would be suitable. It's better than what we have now, which is nothing.
Okay. Any other questions? Thank you. Next on our agenda is public comments. Members of the public in attendance at this meeting have an opportunity to make a comment at this time. Are there any? I don't see any. If there are no comments from the public, we will proceed to the next item on the agenda, and that's our executive and closed session. This is a closed session to discuss ongoing confidential investigations pursuant to DC Official Code Section 2-575B14, to consult with an attorney to obtain legal advice and to preserve the attorney-client privilege between an attorney and a public body pursuant to DC Official Code Section 2-575B4A, to discuss personnel matters including the appointment, employment, assignment, promotion, performance evaluation, compensation, discipline, demotion, removal, or resignation of government appointees, employees, or officials pursuant to DC Official Code Section 2-575B10, to deliberate on a decision in which the Ethics Board will exercise quasi-judicial functions pursuant to DC Official Code Section 2-575B13, and to discuss contract negotiation strategies pursuant to DC Official Code Section 2-575B2. May I have a motion to enter into executive session?
I'll offer the motion.
Second.
Okay, it's been moved and seconded that the board enter into executive session. All those in favor, please indicate by saying aye.
Aye.
Any nays? Hearing none, it is now, what is it? 10:39, and we are in executive session. Okay, the time is now 11:22, and we are back on the record. This concludes the meeting of the DC Board of Ethics and Government Accountability. There are no matters to report out. The next monthly board meeting will be held at the Board of Ethics and Government Accountability here at 1030 15th Street Northwest, Suite 700 West, and virtually on May 2nd, 2026 at 10 a.m. Everyone have a great holiday. Thank you.